Good afternoon, ladies and gentlemen. We would like to welcome you to our workshop on customary use. We're trying to find some more chairs for the ladies, so we're getting kind of tight in here, so if not, you're certainly free, if you don't think you're going to get trampled on, to sit on the floor. But we're trying to find some more chairs for you if possible. At this time, I'd like to let you know, please, that this is a workshop for the commission to hear the presentations by Dr. James Miller. That will take approximately about an hour and a half, hour and 15 minutes. And then after that, we will take comment at that time. This won't be a question and answer period. It will be if you'd like to comment. Your comments will be limited to 3 minutes. Thank you. And I have a sign-up sheet for those of you that wanted to speak. I will take you in order. But we will convene this meeting at 7 o'clock. So it is now 4 o'clock. Dr. Miller and Mr. Theriak, if you would like to get started.
Good afternoon. As the chairwoman indicated, this is a workshop. We're going to hear from Dr. James Miller regarding the research that he has done on the factual predicate for customary use on the beaches in Walton County. It is not to discuss the proposed ordinance. We'll do that on Tuesday. This is limited to the research that Dr. Miller has performed. And with that introduction, I'll turn it over to Dr. Miller.
Okay, would you spell, I know she knows how to spell it, but will you spell your name for Dory, please?
T as in Tom, H-E-R-I-A-Q-U-E.
Thank you,
Thank
sir.
you. Go ahead. Dr. Miller.
Madam Chairman, members of the Commission, thank you very much for the opportunity to speak today. My name is Jim Miller, and I do business under the name James J. Miller, PhD, LLC. I'm a one-man show, so to speak. My area of interest and expertise I call heritage management, and we'll learn more about it as we go along. I know that this is an important and significant issue. I'd like to take a minute to talk about my credentials and my qualifications to do this research. As you can see from my hair, I've been doing this for a long time. I am approaching 50 years of research and study and learning and training in the archaeology and history of Florida and the Southeast United States, and to some extent in the Caribbean, in the Bahamas. I took a bachelor's degree in anthropology with a specialty in archaeology in 1970, and that's where I went to archaeological field school. We focused particularly on the Gulf Coast of Florida. So while I have never dug in Walton County or done work here, I'm familiar with the cultures for over a long time period of this area. I left Florida to take a master's degree in anthropology at Duke University, also specializing in archaeology there, and graduated in 1973. Came back to Florida, worked for the state, and worked as a consultant in cultural resource management. In mid-career, I became interested in thinking more about the future than wondering about the past, and I decided to go back to school and study city and regional planning. I was fortunate to be accepted at University of Pennsylvania, where I took a master's in city planning in 1985 and eventually received the PhD in 1991. My dissertation became a book. It's called An Environmental History of Northeast Florida. As we'll see when we go along, environmental history is not simply about the environment. It's about the people who live in the environment and how the environment changes over time and the people change over time. And it's a very good overarching way of thinking about what happened through time on a piece of land. I've been a registered professional archaeologist since 1977. I was hired as the state archaeologist of Florida and the chief of archaeological research in 1983, and I held that position for 20 years. I had a lot of that, so I left in 2003 and began to consult again. So now I offer services in historic preservation, cultural resource management, I'm very interested in applications of GIS, or Geographic Information Systems, to history and archaeology. I advise on architectural history and historic cemetery preservation, public policy, and so on. I have more than 100 papers and presentations and publications, including 2 books. So I'm here to talk with you about the issue of customary use and describe the historical basis for deciding whether customary use exists in Walton County or not. There are 4 elements in the law that relate to establishing customary use. One of them is whether the use is ancient, is the use without interruption, is it free from dispute, and is it reasonable? And we'll talk about those in more detail. The goals of my study were to understand the timing and the duration of use of the beach. That is, when did it begin, when did it end, how long did it last? There were periods when the beach was heavily used and periods when the beach was not heavily used. When were those? All beach uses have a location. They exist so in time and they exist in space. There are many types of beach use that were revealed by the historical research, and I'll talk about most of those at the end. I'll summarize them, but you'll hear about them as we go through the narrative. And they are much wider in scope than what we might think of today as typical uses of the beach. Over time, I wanted to identify the individuals, the families, the social networks, the friendships, the relationships that relate to beach use, and understand how people were on the beach, what they did with each other, and what were their patterns. The research revealed beach communities, and it also revealed types of uses that did not exist in the beach communities but extended beyond them. And ultimately, in the biggest sense, we want to understand in this study the traditions and the customs that relate to beach use. Now, custom is a word that's been thrown around a lot. As an anthropologist, I consider that custom is not the sole purview of attorneys, but rather that it's a concept that we all understand in a particular way, and anthropologists and archaeologists have thought about it a great deal. So we've applied some of those methods to understanding the customs and traditions on the beach. Finally, in the study, we want to collect and organize and interpret all of the evidence that has been accumulated. So I use computer databases and GIS, Geographic Information System tools, that is computer mapping, to organize and understand such a complex body of events and relationships over time that happen in such a wide area. We reviewed narratives, articles, studies by historic preservationists and others, public records. We interviewed people who had long experience in the beach, both personally and also by way of family background and tradition over the generations. I reviewed photographs and maps and videos, and my purpose was to construct a chronological narrative of beach use in Walton County. So at the end of all of that, I built as full a picture as I could, controlled all of the data sources and the facts that resulted from the research, and then analyzed and interpreted those findings in relation to customary use. I used sources of evidence that you would all be somewhat familiar with, but probably not have a lot of experience with, so I'd like to go over them for just a second. The first is archaeological site information. We'll discuss these in a little bit more detail as we go along. But the Division of Historical Resources, where I used to work as state archaeologist, maintains a file called the Florida Master Site File of all the recorded archaeological sites in Florida. And these are available in GIS format, so I can download them into my mapping program and keep track of them and analyze them. I looked at U.S. government surveys and patent deeds. Those are highly accurate representations of the land surface with some cultural features from very early time periods. I looked at subdivision plats, public records from the clerk's office. I looked at historical maps, especially USGS quadrangle maps that began in the region in 1936. I made great use of newspaper articles, and there is a surprising number of them about beach use. And I made extensive use of aerial photography, and we'll look at that in more detail in a second. But aerial photography you probably could best relate to by your experience using Google Maps. And the GIS essentially builds a Google map with time layers in it, just like the time slider in Google Maps. I looked at historic photography and video, and I was able to participate in interviews of local people who have used the beach over a long time period. The study area runs from county line to county line, and I cut the top off at the Intracoastal Waterway, which was completed in the 1930s and which formed sort of a barrier to transportation. It was a convenient boundary. So I focus mostly on the beach, but I look in general at the entire peninsula south of Choctawhatchee Bay. The archaeological site information that I used, as I said, came from the Florida Master Site File. I selected from the entire body of site information those sites which dated to no longer than 5,000 years ago. After the Ice Age, when the sea level was much lower, the sea began to rise and it reached its current level, and the beach became more or less at its present location about 5,000 years ago. So that's where the story starts. Although people were in North Florida and Walton County much longer than that. Archaeological sites are places where people have left evidence of their activities. And that kind of evidence can be in the form of garbage, such as in a shell midden made of oyster shells or animal bones. It can be artifacts, tools, pottery. It can be stains in the ground that represent post holes and so on. There are lots of different kinds of archaeological information, and all of that comes from the master site file. A site has a location in time and it has a location in space. We know the boundaries of them, more or less. We know to some extent the functions of the site, what people we think did at those sites when they left certain kinds of evidence. And we also can tell from the artifacts that are collected from the site, generally the time period of occupation. So archaeological sites are not isolated. They represent broad cultural patterns and traditions. And in the southeast U.S. and in Florida, along the Gulf Coast, those traditions and patterns extend over hundreds and, in some cases, thousands of years. Archaeologists have divided them into time periods. They have names that archaeologists assigned. We don't know what the Indians call themselves. But an archaeologist would recognize an archaeological site or artifact from the Deptford period on the northern Gulf Coast in the same way it would be recognized in the Tampa Bay area. So those are very broad, extended patterns of culture and behavior and movement and trade and social exchange. The archaeological site information demonstrates that the use has been ancient. I'm not aware of a quantitative definition of ancient, so we began the study at the earliest point of human occupation and carried it forward to the present. This map shows the Native American archaeological sites recorded in the Florida Master Site File. The red lines are the boundaries of the sites, and the yellow notations are the site numbers or site IDs for each of those sites. There are about 80 archaeological sites recorded in the peninsula, and I would like you to notice the pattern of site distribution. I said already that human behavior is patterned, it's certainly not random, and the location of archaeological sites is hardly random. In Walton County and in virtually any other part of Florida, along the coast, you would find sites distributed primarily along the water's edge. And in this case, that happens along the beach, and it also happens along the south shore of Choctawhatchee Bay. Now, Native people occupied sites. They lived at sites for certain parts of the year. Their occupation could be seasonal or it could be permanent. Their populations could be small or they could be large. They vary through time. And they represent a network of behavior that crosses the landscape and crosses the waterscape throughout the year in a variety of opportunities to gather resources, to be at the best place to live, to have social relations, to trade with other people. So these are not static in the sense of one thing happened at one place at one time. They represent patterns of human behavior and human organization, of which Walton County is a part. I want you to notice for just a second how the recorded archaeological sites are distributed along the coastlines and how they are entirely absent from the pine flatwoods in the middle of the peninsula. And that reflects a prehistoric orientation toward the water. The water for prehistoric people is important in a variety of ways. It is a food source. If you live on the beach, you have access to the land and you have equal access to the water. That access to the water for prehistoric people happened with log boats, dugout canoes, we're used to calling them. And throughout Florida, the canoe was a primary means of transportation. It carried people, it carried goods, and there have been archaeological discoveries of as many as 100 canoes in a particular lake in Alachua County. The canoe was the mode of transportation. And if you have a canoe, you don't carry it across the land. They weigh hundreds of pounds. They can weigh 1,000 pounds. You keep it on the beach. You launch it from the beach, and you take it back to the beach when you're done with it. So having a canoe living at the water's edge is like living on a highway network. Instead of overland routes through pine flatwoods, it's much easier to travel by canoe across the water and from the beach or from the bay. Indian people had access to the river, the Choctawhatchee River, all the way up, had access to other rivers, had access to locations across the coastline and other bays as well. In the study area, there's one archaeological feature of singular interest to use of canoes, and that is a prehistoric canal that was dug between Horseshoe Bayou and Fuller Lake, which empties into the Gulf. And it was a way to move from the bay to the Gulf without having to go to Destiny's Pass. You cut 20 miles off of your canoe trip by having a canal that would run through, I think that's about a half a mile of distance. And in fact, canals like that and other kinds of engineering structures and earthworks are common in the archaeological record and are better known even from South Florida, where the land is much flatter and where people also use canoes to travel great distances. This is an engraving by Theodore Debray of a painting by Jacques Lemoyne, a Frenchman, Huguenot, who was the chronicler, the artist for the trip of the French to establish a settlement in 1564 at the St. Johns River. It's one of the earliest and one of the few depictions we have from that time period of canoe use, but it does demonstrate the size of canoes. They have been described as holding as many as 20 or 30 people, and the use of canoes. This charming painting is by an American painter of Indians named George Catlin. He's famous and painted all over the country in the early 19th century. He spent some time in Pensacola. He painted at Santa Rosa Island, and these are Seminole people. They would be Creek Indians from South Alabama. And during this time period, moving down into Florida, prior to the Seminole War, they're drying redfish, which he describes as their favorite food, their chief source of food. So you can see the dunes of Santa Rosa Island in the background. This is probably, 15 miles from where we stand right now. And it would be a typical use of the beach and the typical Native American scene for this time period. To have a painting of it is amazing. So I'm glad that we could find it. In the colonial period, prior to statehood and after Spanish contact, there was a high degree of exploration and documentation of this new land. And the British were here for 20 years, from 1763 to 1783. They were much better at mapping and documentation than the Spaniards. And this is a map of Choctawhatchee Bay dated 1766. By the surveyor George Galt, who left from Pensacola. He mapped from Pensacola all the way to Cape San Blas. And what's called the Bay of Santa Rosa on his map is Choctawhatchee Bay, of course. You can see Destiny's Pass in the lower left. Along the coastline on the south side, on the bottom of the picture, are depicted a couple of notations about the red bluff, the yellow bluff, the smooth white beach, and so on. Farther beyond the border of this picture, there's depicted an Indian village, a trading village by the Choctawhatchee Bay River. Florida became a state in 1845. It had been a territory for about 2 decades before that time. The territorial period is when governments organized themselves to some extent to be ready for statehood, and that happened in Florida in 1845. Once statehood occurred, the push of the federal government is to move land out of U.S. ownership into private ownership. And they do this by way of township surveys. You're probably all familiar with this. A township is a square of land measuring 36 square miles, 6 miles sections on each side. And they began in this area in 1849, relatively early. We put all of those maps into the GIS. We use them for various purposes, but along with the field notes, they provide a very thorough and early and detailed depiction of the landscape. Now, at that time period, in the 1840s, when those township surveys were done, no one had settled yet on Choctawhatchee Bay, but by the same token, all of that land was in federal ownership, but none of it was in private ownership. There were additional surveys called dependent resurveys that began in 1917, but mostly occurred in the 1940s and 1950s after World War II, to further subdivide a few parcels that were not sold as original large government lots. Those are dependent resurveys. So the survey and the issuance of a patent deed following a survey wherein the land is described is the first conveyance to a private owner. And prior to that point, it's questionable whether there is such a thing as the notion of customary use. Absolutely there was use, but there was no person to object to that use. So the concept of establishing a custom of use didn't have the meaning that it does today. These are the dependent reef surveys along the Gulf. They're quite small, and their land acreage per lot averages about 1 acre, whereas the original government lots from the 1840s and 50s, they average about 40 acres. So the deeds issue ownership to the land. The first one is from 1890 or 1893 to Captain Gray at Grayton Beach. They lasted all the way up until 1956, although they had an interesting distribution in time, which we'll see in just a second. They can, when they're in the GIS, convey the picture of how ownership changed over time and what was the distribution of that change in ownership from federal to private. They represent the first opportunity for an area to be settled and to develop, to be built. Prior to the conveyance of land out of U.S. ownership into private ownership, there was not an opportunity for someone to sell land or to build a store or to provide a service or to build a house on that land. We analyzed 4,417 acres in 120 different beachfront deeds. Two examples of patent deeds. They're really pretty simple documents, one page typically. The first one is from 1903 and the second from 1954. They describe the land in township, range, and section and lot, and some of them attach restrictions to the land, such as an easement for a public right-of-way. So this is the distribution of patent deeds across Walton County, and you'll notice by looking at the red dots from 1893 to 1929, 95% of that 4,400 acres was already moved out of government ownership into public ownership before 1930. There were a few more deeds in the 1930s. There were none in the 1940s, probably due to World War II. And then for the time period of 1950s to 56, there were 49 deeds, but they represented only 1.5% of the acreage that was conveyed by patent deeds. The first patent deed was issued to Captain Gray in 1890. It was canceled and reissued again in 1893. That was the beginning of Grayton Beach, and Grayton Beach was the first subdivision in Walton County. And this is a very early period for beginning of a coastal village and subdivision and offering lots in Florida.
What date was that in Grayton?
You can answer that one question, but then you'll have to wait.
Oh, okay.
1890s.
Okay, thank you.
Another picture from the same time period of the Armstrong family, and now we're beginning to see names and people who are part of families that have been here since the early days and who have descendants who are still active in the community today. This picture is interesting to me because it implies that use of the beach is not limited to the area directly south of where you happen to get to the beach, but rather you could use your wagon or you could ride your horse and you could go parallel to the coast up and down the beach as far as you could go in any direction. And we see that pattern of perpendicular beach use throughout time, whether it's by vehicles, four-wheel drives, horse, walking, jogging. People don't just stay in one place at the beach. They enter the beach at one place and then they spread out. This is the Washaway, probably all familiar with this photo and the name. The earliest hotel in Grayton Beach. Again, the photo is from the 1890s, and there are 2 horses and carriages here, probably 20 or 30 people there at the hotel, and that was described in newspaper articles as a fairly typical way of being at the beach with a large number of people in the hotel. Being at the beach was such a traditional and important part of the way of life of people in this area, not only from Walton County, but also from South Alabama, that there was in the Defuniak Herald a column devoted to it, and it was called the Grayton Beach News. Many of you have probably seen that. And we analyzed 63 news articles running from 1906 through 1954 from the Defuniak Herald and the Pensacola Journal about the beach. Those articles provided a date when people went to the beach, the number of people who were there or who went along with that party, their names, and their activities at the beach. So this is, for a historian, an amazingly rich and detailed body of evidence. It's unusual to have that much information about any kind of use during any time period, but to have 63 articles documenting or naming or enumerating 943 people over a 50-year time period at the beach, that's kind of a gold mine. So we learned a lot from that, and we'll summarize that at the end. Those articles reveal the beach uses, but they also reveal the cultural patterns. You see the same patterns over decades in ways of using the beach and who was there and what they did while they were at the beach. It also reveals the individuals and the families and the traditions. Quick sample of some newspaper clippings. These are from the Pensacola Journal. They talk about the opening at Inlet Beach of the new resort. They talk about who went to Grayton Beach. I won't read them for you, but they're extremely detailed. And again, these 2 from the Defuniak Herald. The one on the left is an example of the column called Grayton Beach News, which appeared during the summer months, every week or every other week or so. And the one on the right is an advertisement for the Grayton Beach Hotel, which occurred at the time that Mr. Butler bought property in Grayton and began sort of the second phase of development there. Seagrove Beach was another early community, and we have photos. We have lots of descriptions, but we have photos from the 1920s. There was a dance pavilion in the dunes at Seagrove. There was live music. People would come from all around. It's described not just from Walton County, but all over South Alabama and North Florida. This was a place where people did the same kinds of things that we do today, but they looked different doing it, and they did it in a different location and a different time period. But there is so much continuity between what we find in the historical record and what we ourselves are familiar with doing at the beach today. Seagrove Beach was further developed in the 1950s, and I heard recently that it's further developed again last week. But it is a long-standing beach community, and lots of the interviewees talked about their time at Seagrove Beach. Now, in the GIS, we used maps as a way of conveying information over time in decade time periods, as a way of analyzing, as a way of keeping track what happened and where it happened, and I won't read these to you, you have a copy there, but at the end of the 1930s, you can see from the red dots, which represent the patent deeds, that most of the coastline was already taken up. The road network was not extensive yet. Highway 98 was completed in 1936, quickly destroyed by a hurricane, I've read, and rebuilt, which took a couple of years. But I want you to begin to watch the road network that runs from Highway 98, especially south, and there are two categories to pay attention to. The, let's call them improved, because they wouldn't necessarily be paved at this early time period. The larger roads are in blue dots, and the trails, sand trails, as they're called on the USGS maps, are in kind of dark purple solid lines. So these road networks represent the way that people got to the beach. And it's important to distinguish beach access sort of conceptually. Think of beach access as a necessary condition for beach use. You can't use the beach until you can get to the beach. So the roads are significant and begin to show a pattern which I think of as kind of a sieve. And people are moving from the highway through the flatwoods down to the beach, down to the Gulf, at various locations by various routes, so that they can use the beach in various ways. And the more dense the network of ways to get there, the larger the number of beach users and the greater the amount of beach use. So this map takes us through the end of the 1930s. This is a typical view of Grayton from the 1940s, certainly an established community. You get a good sense by the 40s that the roads are passable, that people can get there by car, back and forth. Thank you, sir. That was not the case in earlier time periods. The travel was very difficult to get to the coast. It could take a day or 2 days from Defuniak or from South Alabama. And once you got there, the last thing you wanted to do was turn around and do that again and go home. It was typical for people to think of being at the beach for the summer months. They could have stayed there the entire 3-month period. They could have come for a few weeks. They could have come for a weekend. They could have come multiple times. A typical pattern I read and heard about was that the dad would stay home and do his business during the week, maybe come down on the weekend or for a vacation, but the rest of the family might stay at the beach for a longer period than that. When people were at Grayton Beach, many of them had their own beach houses, but some beach houses were for rent, just like today, and many people visited the houses that others owned. So let me explain a little bit about the aerial photography that we used. It comes from a variety of sources. It was shot primarily by DOT and also by the U.S. Soil Service in the early years. It's maintained by the DOT and the University of Florida and the USGS. It's black and white and it's in color. It ranges from low resolution to extremely high resolution, and as you would imagine, it gets better over time. The aerial photography, you could think of it as a slow motion film. If you have a lot of aerials to overlay on top of each other in the GIS and you can turn them on and off, you can see how the land changes from one year, from one time period of photography to the next. So we had years 1941, 1949, 55 and 56, 1968 and 69, 1972, 1974. By 1980s, it became very common. Our study didn't go quite that far, but There is modern photography available to everybody all the time now over the internet. The aerial photography reveals beach paths used for beach access, and it also reveals the cars parked at the head of the beach path for those people who are using the beach path that day to get to the beach. It reveals dirt trails and roads to the beach for each time period, and it reveals structures and the infrastructure of subdivisions. This is an aerial photograph from 1974 at Stewart Lake. This is on the western side of the county, as you would know better than I. It's a stretch of the coastline where the highway is very close to the water's edge. So think for a second again of the difference between beach access and beach use. For someone to be able to use the beach in this particular area, they had to traverse, say, 100 feet of dune. And the way that happened was to create, by use, a beach path. And then typically, people have told me, you stayed on the path, you kept them open because you didn't want to get in the briars, you didn't want to get sand spurs in your feet. This map shows, by red triangle, the beach end of each of the paths that I could interpret in the aerial photography. There probably are a few more, but I wanted to be conservative about that. And then the arrows in blue on the top show the parked cars where people got out on the highway, parked on the shoulder, went down the beach path, and got to the beach. It's 4,100 feet between the two outside red triangles, and there are 36 beach paths in that distance. And the average distance between one beach path and another is 114 feet. So, again, this is like a sieve. This is a way that people just funnel in a little bit and then come back out again. They get on the beach and then they do whatever they do when they're on the beach. So, when there are so many beach paths, first of all, it indicates to me that the geography is good for walking from the car that you could park to the beach. But second, it indicates that there's a lot of use to the beach for there to be a path every 100 plus feet. So in the 1940s, you begin to see an increase in the number of trails extending from the highway south, and there begin to be a few more improved roads. There are more subdivisions in the 1940s. People who received land in patent deeds are beginning to divide it up. Folks are buying beachfront lots. Dune Allen is a subdivision of this time period. And each one of those subdivisions represents not just the people who live on the beach, but also the people who live in the entire subdivision with access to the beach. So again, we're interpreting the evidence a little bit. We're making a logical leap that says that if you live in a beachfront subdivision, it's because you have an interest in using the beach. This is the total number of beachfront subdivisions. I don't remember the exact count right now, but throughout the 1970s, the beach was beginning to become full, if you will, of opportunities to develop subdivisions, and the pattern of real estate on the beach was beginning to change from lots and single-family beach homes to more intense uses like townhomes. The plats are from the county clerk's plat book. They run from 1890 to the present. The plats can indicate to you, when you put them in the GIS, the location, the boundaries, the lots, number of lots, their size, the roads, and the dedications. Plats have dedications on the face. typically for a reservation of some right, and that reservation on the face of the plat is accepted by the county. Lots of plats have beach access reservations, and lots of them have seaward lot lines that do not extend all the way to the mean high water, and some of them have notations on the face of the plat that says beach reserved for public use or something to that effect. So the subdivision plats, when they're all assembled together, that is those which touch the beach, provide a chronology and a pattern of available places for people to live at the beach. This plat is like one I've never seen before. Sea Highlands was issued in 1949, and every lot on this beach is surrounded by paths to the beach. There's lots of information in the narrative, in the documents, as well as from the interviewees, about how people cared a lot. Those people who were building subdivisions and cutting up their land cared a lot that they could protect the environment, that they would attract people to live there who cared, who thought like them, and also that the beach was a place that someone should always have access to. So this one says beach reserved for public, Seagrove second edition. The beach is, quote, dedicated for swimming park, unquote. My favorite, White's Gulf View Estates, doesn't add that sort of notation, but has some fishing boats offshore, water skiing, and then on the beach, a couple on a blanket with a beach ball enjoying the beach. 1950s, we see again the same pattern without getting into too much detail about the quantity, but the density of improved roads to get to the beach is increasing, and that's because there are subdivisions and places to go at the beach. Keep in mind that in the 1950s, 30A did not exist. It's a product of the 60s, and people primarily reached their beachfront locations by coming south from Highway 98 rather than by traveling parallel along the coast, at the coast. It's a charming photograph of Dune Allen in the 1950s, and I take this to be a typical beachfront scene from that time period. The houses are very modest. People are obviously enjoying themselves on the beach, and it certainly is a different picture than you might see if you were on the beach today. And I think it's expressive, to me at least, about how there is use, but it's very different than the way that we think about use. And sometimes we might judge use by wondering whether it looks like it does today. It doesn't look like it does today. It looks like the time and the place that it came from. It looks like the tradition and the family practices and ownership that were peculiar to that time period. Grayton Beach in the late 40s in aerial photography. Definitely an established community. The development is pushing outwards away from the original layout of the town onto an area that probably is somewhat dynamic due to the outlet of the adjacent lake. So another decade map from the 1960s, we see again the same patterns, more trails, more improved roads, more access to the beach, more subdivisions on the beach. These are just typical photos, these from the western part of the county around Miramar, Frangista Beach, the apartments, Coastal Grill. And again, these look totally different from anything we would expect to see on the beach, but that was pretty hot stuff in that time period. By the 1970s, Walton County is becoming, certainly it has been discovered, it has been developed, it's becoming fairly dense. And from the point of view of historical research, things change in an important way. From the 1970s forward, let me say it differently, from the 1970s backward, I was interested in ways that people could get to the beach, what was their beach access, as a way of documenting that they were using the beach. And most of the difficulties to overcome in getting to the beach had to do with distance, or had to do with the lack of roads, or had to do with the type of vegetation. Gradually, but at some point definitely, in this time period of the 1970s, a lot of the beach became difficult to get to, not for those reasons, but rather because it was built up and there were private homes and developments and no access across large parts of the beach. So not long after that, then public beach access came into play as a way of getting people to the beach. Just some uses which are untypical, but which are representative of the many, many ways that people have used the beach over time. Riding horses on the beach is known from the early 19th century, the early 1900s, especially in relation to the large cattle herds from the Miller operation that used to range the beach before there were fence laws. Driving used to be unregulated on the beach until the 1970s, and informants and documents talk about driving from one county line to the other county line, about driving from Seagrove up to the little gas station, Bishop's gas station near Frangista, to buy some gas and to get some groceries. And driving was a way of being on the beach, but it also was a way of extending your range along the beach. You might use the beach, if you didn't have a vehicle, within a quarter mile or a half a mile or 2 miles of where you entered the beach, but if you had a vehicle and you could traverse the beach, you can run county line to county line, and many people did. A house was moved across the beach. The beach is kind of like a highway. Some people talked about it being easier to drive along the beach than to go all the way up to Highway 98 and then come back down again on the other side of the county. So I'm sure there was an element of fun involved in it as well as efficiency, but the beach is always kind of a highway too. In the lower left is the 4th of July parade that ran between Grayton and Seagrove for a number of years, maybe still, I don't know. And by this time, the beach vehicles are modern four-wheel drive. Prior to that, in the early days, beach vehicles were sort of crude and makeshift. They had not so much air in the tires, and maybe the doors didn't hang on very well, and you just made your way. The picture in the upper right is the first regatta from 1981, I believe. And I think that was a very popular activity for a certain time period. I'm not sure if it continues today. So I have 4 pages, 4 slides of documented uses of the beach, which were revealed in the historical documents or the interviews. And I won't read them to you. All of them happened. They were described. This list does not include the kinds of things that I could see today or that I would think of when I wonder what people do at the beach. We already know that people have blankets and they play Frisbee and they walk their dog and so on. These are only the things that were documented in the historical and the archaeological record. Lots of mentions in the record about how much people fish at the beach. They fish from a stationary position. They fish from four-wheel drive vehicles. They're especially interested in pompano and redfish, and we heard a lot of fish stories, which were fun. But that was an important beach use for many people. People climbed the sand dunes, they strolled on the beach, they ate watermelon, they picnicked, they roasted marshmallows, they had a bonfire, families met together, kids played on the beach. You're all familiar with this, I know. But one sense I got that I didn't quite understand at first was that the beach is a place where you pass on your family oral traditions. And I think even more than that, it's a place where you, as a young person, learn how to get along with others, how to hold the values that your community holds. You know, you don't necessarily learn that in school. You learn it when your family's together at a special place at a special time. And people talked about the power of the bonfire and looking up and seeing the stars and watching the constellations, and all of that just brings people together in a social way that I think is very critical about the beach. People could roast a pig, they could watch a meteor shower, they could see the Milky Way. They will always pick up, one person said, always carried a bag and always picked up trash and also picked up driftwood. They would launch an inflatable boat and go fishing and come back to the same place and slide it back up the dune, use fireworks, on and on and on. So let's take all this back now to the perspective of the elements of customary use. Is the use ancient? Is it without interruption? Is it free from dispute? And is it reasonable? Whether the use is ancient or not, I think is relatively easy to think about from the information that has been collected. It began about 5,000 years ago. Interestingly, European people have been here 500 years, so 90% of the use of the beach in Florida at this location and elsewhere was by native people. That native use lasted until probably the 1830s or so. The first private ownership was in the 1890s, again an early date for settlement of the beach in this region. The first subdivision was in the 1890s, and by the 1950s there were already 10 subdivisions in Walton County. Is the use without interruption? It's important to clarify the meaning of the word interruption. It does not mean was the use discontinuous. Use does not need to be continuous in order to be customary. It means instead, did someone take an action to try to prevent a use of the beach? Was it interrupted by an act from a person? All right? And typically that would mean a property owner. From the 1890s to the 1990s, the historical research revealed no interruption in the right or the exercise of use. And except for the last 10 years, all interviewed longtime residents and visitors stated there was never any objection or restriction to beach use.
I disagree with that.
I'm sorry, sir, don't interrupt.
Is the use reasonable? Based on the historical research and the interviews of the longtime residents, it appeared to me that the use of the beach was a normal and expected human activity, and it's not something that's peculiar to Walton County, use of the beach is relatively universal. It's within the realm of the ordinary. It's not something that would be unusual for a person to do. It's appropriate to the character of the land in the sense that the dry sand of the beach is not suitable for traditional uses of land such as agriculture or building a home or developing. And finally, visiting the beach, it seems to me, was universally viewed as a healthful, enjoyable, and relaxing experience. That concludes my presentation. Thank you very much.
Mr. Theriak, do you have anything at this time? All right. That will, let's see, it's 5 o'clock now. That will give us some time for those of you that want to come up and comment. We are going to take 10 minutes right now to let everybody stretch their legs before we start that. And I might suggest maybe some of you gentlemen, if some of these ladies are still standing, you might give them an opportunity to sit down for a while. But we'll be back with you in 10 minutes. It's going to take a minute to get these people quiet. Sydney, I'm ready to get. We can get started without her. We have 3 in the room. We will now get started on your public comments. You're welcome to comment. Each one will be allowed 3 minutes, so you need to think about what you want to say and be succinct. I will start. I have 36 names on here, and we will stop at 6:59. So, so we'll get started, and I always ask that you forgive my pronunciation of your name, okay? I know the first one is Beverly Humphrey. Beverly, would you like to come forward? Again, as we always do, if you will state your name for the record, and you will spell your last name so our clerk can have an accurate record of your last name.
Right. Thank you all so much for allowing me to speak. My name is Beverly Humphrey, 320 Beachfront Trail number 10, my property for over 40 years. My last name is spelled Humphrey.
Thank you, ma'am.
In our representative democracy, the United States of America, private property ownership and the achievement of such is one of the oldest basic tenets of our laws in existence. As such, as elected officials, it falls upon you all to support and protect these private property ownership rights. Please do not support any action now or ever that assaults the right to deeded ownership. The current assault is called Draft of Customary Use Ordinance. The case cited as justification for this assault is not applicable. It was between 2 commercial entities and had nothing to do with private property. So you need to review that case. The allusion to the dry sand area being customarily open for use by anyone is skewed. Property in this country from founding is privately owned either by purchase or a land grant from the government. Therefore, use of the dry land area was by trespassers if they were not the owner. The customary use argument is nothing less than a de facto conversion to public from private. The only difference between a robber taking my property and the county commission taking it is that compensation is required under the 5th and 14th Amendments of the U.S. Constitution. The takings clause is the last clause in the 5th Amendment, and it says that conversion to public use from private must be compensated. And I used the 1988 costs. If on Walton Dunes, where I live, the 280 front feet of beach would require compensation to the Walton Dunes owners totaling to $11.2 million. This money could be spent better on preparing better roads and trying to fix the traffic problems on 30A rather than assaulting private ownership on the beach. The buffer zone described in the draft protects what is already protected at Walton Dunes. The dunes that are between the buildings and the dry sand area, that means meaningless eye candy buffer. The dunes are protected by state law. The draft conversion would require adjustments in taxes, inasmuch as loss of property rights to beach front would reduce the theoretical values of property and structures to be the same as inland property.
All right. Thank you, ma'am.
Thank you.
Appreciate it. Next, I have Harry. His middle initial is P. Pasturzen. Am I close? You live at Costa del Sol? Is that a clue? He must have already left us. All right, Mr. Watson, you're giving your time up, is that correct?
Yeah, I'll be Tuesday.
Okay. Sissy, it looks like Cannell.
Sissy Canale, last name spelled C-A-N-A-L-E. I'm an owner at Seaside, and I have a petition I'd like to give each one of you.
If you will give it to our clerk, please. Thank you, ma'am.
That's it.
Oh, is that all you want? Oh, okay, I'm sorry. Next, Mr. Goodwin. Is Mr. Goodwin still here?
He's gone.
He's gone. Okay. Alan, is it League, L-E-G-E?
That's close enough.
Okay.
It's Alan Leger. I've been in the Walton County residence since 1978.
Okay, would you spell your name for our clerk, please?
It's Allen, A-L-L-A-N-L-E-G-E. I'm a real estate broker. I've been selling real estate in this county since the 76 on until about 95. I own several properties in Gulf Pines. I'd like to submit a warranty deed that was introduced into a neighborhood plan and approved by the county for Gulf Pines, which specifies exclusive perpetual use of our 1,400 feet of beach. I mean, I appreciate what David Teriak has done for the county. I appreciate the books that this gentleman has written about the history. A gentleman earlier spoke about how the Native Americans, if we're going to deal in the past, we'd be out there scalping each other for land use. I mean, that's what they did. Okay? I mean, this is the president. Even he purported, we're not dealing with the past, we're dealing with the future. The future is right now, here, today. We are deciding, and we're supposed to be in a workshop. We should be talking about the different things that are addressed here in this draft, not about personalities, not about perceptions, not about history. This is a workshop, and nothing has been brought up about what do we do, how do we promote, and I hate to say this, I think this has already been decided by a select few. It's all a money power grab, you know, and I feel for all of y'all.
Do we need to number that, Mr.? No. Okay, all right, okay. Go ahead, sir.
Where do you begin? I mean, the guy got, the other side got an hour and a half? I
Sir,
get 3 minutes?
This is not a side, this
I
was
know,
for
this
us.
is a workshop. This is a
was for us
workshop.
to hear his presentation and for y'all to hear it as well.
Okay.
We're giving you an opportunity to speak, but it was for us to hear his presentation.
All right. I believe that I went through a neighborhood plan that the county asked me to do, all right, to establish guidelines. And here we are, governing body says to me, go out here and do this. We do this. We say, okay, my neighborhood reduced densities on residential homes. Oh, I'm done.
Okay, thank you, sir.
Gee, wow. Thank you very much. I appreciate the
Bagby?
democracy.
BAGB, you think, you know. Thank you, Madam Chair. Just, you know, I would ask that you consider taking a breath on this issue. I think, you know, most of the beachfront property owners are not bad people. And most of the people that go to the beach are not bad people. The beachfront property owners, the ones that I know, they don't mind people walking along the beach. They don't mind people, you know, actually sitting down and watching a sunset or something. What their big problem was is people that behave badly that come to the beach. And it's not always the tourists, okay? A lot of times, some of the worst behavior I've seen is actually from some of the residents of Walton County and some who live in those communities. Because if we could get people just to get along and behave, I think you could get rid of this whole action that you're going to take. There are a couple of questions I'd like to see answered on Tuesday, though, because I've heard two different answers on, does it have to be a parcel by parcel assessment, or can it just be a blanket assessment? I think that's very important, because if it's parcel by parcel, there's a lot of places that have had gates and denied public access. I don't know when Sandestin put their gates on the south side. I know when Rosemary Beach put their gates on the south side that prevented public beach access. But, you know, what is the standard? We heard the standard was ancient, without interruption, reasonable, and free from dispute. And then we heard for the last 10 years, there's been disputes. So is that too long, long enough, not long enough? I'd like to understand what those standards are before I advise the board at One Seagrove Place on what their position ought to be, because there's more questions than there are answers right now. And that's why I would ask that you take a breath. But we just got to get along. And I understand the beachfront property owners. I do. And I work and have worked for beachfront property owners. But there's got to be somewhere, some common ground where people can say, look, you can do this and you can't do that. You know, I don't think anybody disputes that you can stroll the beach. I don't think anybody disputes that you can wade out into the water or that you can watch a sunset on any part of any beach. You know, they might get upset with the chairs and the beach umbrellas. I don't think they would get upset with towels. They definitely get upset with tents. I think everybody wants to get rid of the tents, but I would urge you to go back and try to craft something that everyone could agree on and let us all live together in peace. Thank you.
Thank you, Mr. Bagby. Help me on this one. Is it Jerry?
Yeah, I think so. Jerry.
Jerry, K-A-L-I-S-H?
Kalish.
Okay.
Jerry Kalish with a J, and the last name is K-A-L-I-S-H. Fortunately, most of the people who have gone before me have already said most of what I was going to say, but I would like to reiterate it. The good doctor, with all of his expertise, does only deal in the past. And I don't think there's a person out here that really cares about the past. They're worried about their future. And when they came here, they went through real estate agent or something, they purchased a piece of property, they got a deed, they got title insurance, and they got a description of exactly what they had and what they can expect. It doesn't seem like that is going to continue. That seems to maybe possibility leave open maybe access to certain legal actions. And I don't know which one of you or anyone would want to present to Jerry Jones in front of his place and tell him that the spring breakers are going to be allowed to go in front of his house and throw frisbees, drink beer, and do whatever they were doing in Panama City in front of his house, and that's okay with this community. I'm not sure it is, and I'm not sure that anyone else would agree with that kind of activity. We just want what we came here for and what we signed up for initially. Thank you.
Thank you, sir. It looks like Richard Brighton.
Thank you. Evening, Madam Chairman, Commissioners. I am Richard Brightman. That's spelled B-R-I-G-H-T-M-A-N. I'm an attorney from Tallahassee. I'm here representing 20-plus courageous beachfront property owners who are trying to protect their property rights. And I'll be brief, and I'm not going to quibble with my friend Jim Miller, other than to say he used the word evidence a number of times in his presentation. And evidence is in the eye of the beholder. What he provided to you may be evidence from his perspective, but it is not evidence in a court of law. Newspapers, interviews, those kinds of things are not evidence in a court of law. And that gets to the point where the customary use doctrine in Florida is it's not magic, it's not even difficult. The case laws show that it can be established, and they lay out a pretty clear method for establishing it. But this county is not proposing to follow that method. By proposing to adopt an ordinance, you're taking a shortcut. You're taking the easy way. The way you're supposed to establish customary use is go to a court of law, prove it up under oath, subject to cross-examination, let an impartial judge decide whether or not the facts support customary use. I will tell you, the facts are in dispute in this case, despite what Mr. Miller says. Constitutionally protected property rights are not subject to a popularity contest. They're protected by the Constitution. That you could parade 10,000 people up here and say, please adopt this ordinance. That doesn't make it the right thing to do. The right thing to do is to protect property rights, everybody's property rights. And the way you do that in this case is to follow the law, and if you want to go to court and try to establish customary use, do so. But don't take the shortcut. You should have more respect for my client's constitutional rights than to take a shortcut. Thanks very much.
Thank you. All right, it looks like Alex Andrea. Is there an Alex? Are you going to pass? Okay. Oh, that one's scratched out. Tiffin Hughes. Am I anywhere close? Tiff? Tiffany? Okay, good. Okay, thank you.
Yes, that's me. So Tiffany Hughes, Hughes. I actually thought because this was a workshop, we would have a chance to ask questions. I didn't realize this was just a comment, so I'm going to leave my question as a comment, and hopefully on Tuesday it will be addressed. And I am a Gulffront owner, and I would like to know how my liability is being affected because there's 4 classifications of a person on your property, and they have different responsibilities for if an accident occurs. And I want to know, with the county making an ordinance and inviting people onto my private property, how that affects my rights.
All right.
Hear, hear.
Thank you. Next, we have Tom McGee. Mr. Tom, he's already left? Okay. Jim Miller. She already gone? Okay. Sue Bennett?
Hi, my name is Sue Bennett, Bennett. I'm a new property owner, and when I bought here, no one ever said to me the sand that is in our property was going to be able to use by anybody and that walked down and wanted to squat, trash our beach, whatever. About a month ago when we were here, well, I guess about 3 months ago, time flies, but we were here regarding signs. I was here. I waded through that 3-hour dissertation, and it was passed, as most people opposed it that was here, and you listened to that, at least I thought you listened, until it passed. And when we came down to it for 2 days, we had our beach signs down. We had trash. I had to go down and walk, pick up trash, take care of our beach. We're proud of our beach. That's the reason why we bought here, is because this is the beach that we wanted. We came from Missouri. My dad was a farmer. He had fences around his property. Just because the grass was greener on the other side of the fence didn't mean that his cattle could go over there and eat. We need to protect what we have. This is because that's what we worked hard for. It's our right to have this property, and you guys ought to allow us to have that property. You shouldn't take it away from us. Thank you.
Thank you, Ms. Bennett. Bob Gillard?
Bob Gilardi, Gelardi, and I have been a owner of beachfront property, or what I thought was beachfront property until this meeting, since 1992. And I know that everybody wants to do the right thing. I hope everyone wants to do the right thing. But I normally would be very conciliatory, and I wouldn't make any even apparent objection to the way somebody is doing something. But all of you have the title Republican by your name. Remember, private property rights is a key element. And the one element that you've provided by having a 25-foot buffer would mean literally a 25-foot buffer around your house if somebody came and wanted to do whatever they wanted to do there. Give real consideration to taking something away from people who bought here in the first place with that idea. If it didn't exist, if it wasn't customary use, then why were we given the right to have that property, and what did we buy on that basis? That was something that came with the agenda, came with us. And I think it's important that you consider that we had a property analysis here, supposedly by an anthropologist. And I love anthropologists, but we don't need Margaret Mead to analyze something and then have a situation where we have basically had private property, private access, only private access, and then not have that accounted for. That's existed in Miramar Beach on certain of the properties since the 80s, and matter of fact, back to the 70s. And I know because I've been coming here since the 70s. So give serious consideration to whether this is really going to be in the interest of integrity, your integrity, and the integrity of the county, the integrity of the Constitution of the United States. Thank you.
Thank you, sir. Richard Bryan?
Pass.
Okay. John C-R-U-M-B, Crump?
C-R-U-N-K.
Okay.
Yes.
Okay.
John Crunk, C-R-U-N-K. I have a home at 600 Blue Mountain Beach Road. I've owned it since '99. I have a public access right beside it. I have people come out on my beach all the time, and I have no problem with it. I've never run anyone off or anything, but it really is a problem. You know, a couple of years ago, I built 2 fences. I also paid for the public access 2 fences and put $450,000 in the whole thing to save that beach. So we do have a lot of money invested in it. My real problem is that there's more options that I don't think you people have either just looked over or quit considering. You know, Mike Huckabee had a pretty good idea, and I never heard anything more about it at all. But to do what you're doing, I just think it's going to cost the county a lot of money, which we're having to pay as all these landowners. It's costing us in attorney fees. It's just throwing a lot of money away that could be spent in a lot of different ways. I had an instant, my lot's 75 foot. I was going to go down and put a tent. My wife likes to go to the beach. I looked down there Sunday morning about 7 o'clock. I had 9 chairs right square in front of my property. I decided we just went to church and forgot about it. But you know, you should have something when you own that property that people don't come out at me. Again, I've had it happen a lot of times, but goodness, it does get aggravating that they're there. I paid, in 2015, I paid $15,480 in property taxes. You went up this year to $18,093. That's a $2,613. I don't know whether you're getting ready for your expenses on this other thing or what, but that's a 19% increase. It just seems to me like you could come with some better answers or better solutions. I hope you will try it before you do something. Thank you very much.
And I'm really not sure what this is. Is it C-A-R-O-L, caroling? And then the last name is G-E-A-R-Y?
I think she left.
Okay. Bob Brook? I saw him here a minute ago. Is Mr. Bob still here? Bob Brook? Okay. Annie Briggs?
Ann Briggs, B-R-I-G-G-S, and I might be in the minority around here, but I moved here in 2008 from California, and California the state owns the beaches. It doesn't matter whether you're living in Malibu or San Diego or San Francisco, the public owns the beach. And I just feel like there were no signs when I got here. People weren't kicking you out of Seaside. There wasn't all this big controversy when I got here, and this is why I moved here, is I wanted to be part of the beach. And I couldn't afford to be part of the beach in California, but I just wish there was, I think the vendor situation's out of control, and that's what's causing a lot of this controversy in the first place. There wasn't all the beach umbrellas. The public beaches are being so crowded, and then everybody's moving to the other places, and I just think that there's got to be another solution to this problem. But I don't want to I don't want to be blocked from the beach. I don't think that's fair either. Thank you.
Thank you. Yeah, Jimmy Kuhn. Mr. Kuhn still here? There you are.
My name's Jimmy Kuhn, K-U-H-N. I live in the Eastern Lake area. I come today as a member of the Surfrider Foundation. Surfrider Legal has reviewed the proposed ordinance and will be providing formal written comments to the Commission. Here's some observations made by Surfrider Legal. Beach access is a universal right necessary for the public's enjoyment of the beach. Surfrider Foundation promotes the rights of the public, including all recreational user groups and members of the community, to enjoy low-impact beach access, including the enjoyment of coastal aesthetics. Surfrider Foundation members work, live, visit, recreate on and near the world's beaches, including here in Walton County. and are profoundly impacted by beach access limitations. Surfrider encourages recreational user groups to balance their interests and to work cooperatively with local residents and decision makers to ensure maximized coastal access for all persons. This customary use ordinance is an excellent example of such collaboration between Walton County and the beach-going public and beachfront owners. Generally, this proposed ordinance correctly and appropriately protects the public's common law customary use rights to use county beaches based on the public's historic traditional use of the dry sand areas of the beaches in Walton County. The ordinance represents an important opportunity to protect beach access for residents and visitors alike. We strongly encourage your support. We do have some questions and concerns. Primarily, the concern is about the 25-foot buffer. Customary use is a common law doctrine based on the public's past use of the beach, and Surfrider has concerns that the county may be diminishing any existing rights that the public has in fact established. A 25-foot buffer, particularly tied to landward structures, is too rigid and does not account for the fact that the beaches are dynamic and constantly evolving. Determining beach access boundaries based on fixed landward points is problematic, particularly when anticipating major erosion events like hurricanes, sea level rise. Using fixed boundary lines for a buffer zone will foreseeably and eventually impede the public's right as the seas rise toward structures. Additionally, we prefer no buffer based on the location of structures. In such case, the structures must be narrowly defined and must not include dune walkovers, decks, fences, landscape, sidewalks, driveways, pools, or other non-habitable structures. With respect to any boundary for the areas the public has established rights based on customary use doctrine, we believe a more appropriate basis may be the natural dune or the natural vegetation line. Thank you very much.
Thank you, Mr. Coon. Is it Bullock? Bill Bullock?
Good evening. My name is Bill Bullock, B-U-L-L-O-C-K. I'm sure that there are a lot of people who own on the beach who do not want to preclude others from being able to use the beach. But that's not true everywhere up and down the beach. I live on Eastern Lake, and we have had problems with at least one owner who has chosen to put up signs, call the sheriff anytime anybody gets on his property. One of my concerns is, and I hope you look at this as part of your review, is are these lots actually properly calculated, measured? In particular, we have looked at a lot of documents, starting with government patents and working forward. And I'll just give you one example. Government Lot 14, Section 19, Township 3, Range 18 West in Walton County. That lot was transferred pursuant to original government patent in 1954, and the patent clearly states that it contained 1.95 acres. It changed hands a couple of times, and the last time the lots were put together that were subject to that original government Lot 14, lo and behold, they grew from 1.95 acres to 3.7 acres. All of that growth being southward toward the mean high water mark. We have asked the county assessor, how does this happen? We have not been given an answer other than the deeds were brought in and they got filed. This is an indication to us that this kind of a situation needs to be reviewed as part and parcel of deciding whether someone is using someone else's private property. Perhaps it's not their property to begin with, through no error of their own, but perhaps that is the case. So I would ask that that be entered into the process as you review this kind of a situation. Thank you.
Sir. Brenda Rich, R-I-C-H, Brenda Rich. No, it's R-I-C-H. I could read that one.
It is, it's R-I-C-H.
Thank you for printing legibly.
You're quite welcome. I'm kind of older than everybody else who's spoken. I've been here since 1954. My family has. I wasn't born in 1954. My family bought land here and built a home in 1954. My entire life, I have used Blue Mountain Beach. I do not live on Blue Mountain Beach. I live on the bay. But I have used Blue Mountain Beach. We're now in the 4th generation of taking our family over there to that beach. Let me say this. I think Florida is a little late on what you're looking at. Let me tell you some other states and what they have done. Your customary usage law, which I agree with, has been used in 2 states. The state of Oregon, it applies the customary use doctrine for all of their beaches. The public has the right to use the dry sand beach up to the vegetation line because they were having so many difficulties. After that, Hawaii followed Oregon's example because they thought it was great. So when you go to Hawaii, you can use all their beaches. New Jersey used something called the public trust doctrine. I don't know if you have heard of that, but it states that swimmers, boaters, and fishermen are permitted to part of the dry sand beach falling within private property to rest and relax. If you get that, that's swimmers that can rest and relax on this beach. This went to their Supreme Court because the private homeowners did not like that. The Supreme Court upheld the public trust doctrine. In Texas, they did the exact same thing. They used the public trust doctrine, and all of their beaches are public beaches, regardless of homeowner. The homeowner can own to the beach, but it's public access to the vegetation line. And there was one, North Carolina also used the public trust doctrine for their beaches. As you know, Walton County, all their advertisements are for miles and miles and miles of beautiful Sugar Sands Beach. Come and visit us and swim in our emerald green waters. But if you limit their access to the beaches and to the waters, are you going to get tourists in here to come and see the beach, but they can't use it? Is that what you're looking for? Tourists are your bread and butter. Well, you don't have Walt Disney World in Walton County. You don't have SeaWorld. You don't have Miami nightlife. You don't even have Panama City nightlife. You have the beaches. That's what you advertise, is the beaches. And you're trying to take it away. Let me tell you what public trust doctrine is.
Ma'am, hold on a minute. Now, you have had a right to speak. This lady has a right to speak. Thank you, sir.
Public trust doctrine is the principle that the sovereign holds in trust for public use some resources such as shoreline, regardless of private property ownership.
Thank you, ma'am. All right. I think it's Maddie Savor. Am I close? M-A-D-D-I-E, Maddie? That's you? Okay. Oh, okay.
Maddie Savoy, S-A-V-O-I-E. I like tourists. I'm a property owner on the beach, but I like tourists. They walk down the beach on the wet sand, and that is where I met my new best friend, a couple that came from another state that I met looking at the water. And from there, they have purchased a home here and hope to be a full-time resident. That doesn't change private property from public property. I respect the laws. I uphold the law. I am a little concerned with the Section 2, number 1, that I'm going to paraphrase, talks about no individual group will impede or interfere with the right of a public beach to be utilized in the beach that's owned by private entities. So to me, it's an oxymoron. If hot and cold, up and down, those are two total different concepts. Private and public use are different concepts. They can commingle. I'm happy to share the sand, and just as a private property owner, I'm concerned about the 25-foot buffer zone. I just want to have the legal right for what I've paid for as a private property owner, and to not be liable for someone else to get injured on the property, and to understand the buffer zone that's voluntary. Well, do the tourists know it's voluntary? And how will that be enforced if they don't? In a polite way, how will that be taken care of? To me, I agree with the gentleman that said that this could be thought out, mediated, what works for both groups, and find some common ground. The beach is a treasure. It is for everyone. But the boundaries of the private property of the homes and the condos that have a legal deed should be honored and respected, and the constitutionality of that should be upheld. So I look to you to consider and explore this, and not take this proposal permanent, but to make a working document and work more and listen. I thought this was a workshop too, and there would be more exchange of, well, what if we tried this? And to work and talk and mediate solutions, not arguments. Everybody has their position, but it can be worked out if respecting the rights and the law. So I thank you for listening.
Thank you, ma'am. Scott Koval.
Scott Koval, C-O-V-E-L-L. I'm a Gulffront owner in Grayton Beach. I echo the sentiments of a number of people that have spoken that there could be a more palatable way to go about this to satisfy the needs of the public to access the beach, whether that's the wet sand portion or a portion of the upland portion, the dry portion. In Grayton Beach, I think Grayton Beach has a unique history in the sense that some of its owners in the 70s or 80s, I don't recall, were instrumental in engineering the purchase of what is now the public area from, I believe it was the Butler family. And so I don't know of any Gulffront owner in Grayton Beach that has been actively opposed to anybody using the beach, private use of anybody, setting up in front of our house. They set up in front of our house. They walk along. That's great. That's all part of the context and the beauty of the place. So in Grayton, you have a large portion of the beach that is set aside expressly for public use. You're bounded on either side by state-owned land that is clearly for public use. The handful, 7, 8 Gulffront owners that own to the mean high water mark in Grayton Beach, including my family, have, to my knowledge, not impeded anybody's access to the beach. What the ordinance is silent on is the notion of concessions and the county's willingness or desire to perhaps sell licenses or allow public entities to operate for-profit businesses in terms of renting beach equipment and that sort of thing in front of private property. So people walking up and down, great. As to Mr. Brightman's point earlier about evidence, I mean, I would cite as evidence the fact that the government, be it the federal government in the patent deeds, and indeed Walton County commissioners themselves do know the difference between private ownership of land and not, because when they crafted the patent deeds in Dr. James's statement, he did point out that there were distinctions between some deeds that granted ownership to the mean high water mark and some that expressly reserved public access. So clearly the government knew the difference then. Dr. James also cited the people driving up and down the length of the beach. That stopped in the 70s or so after they granted permits. People could drive in front of all the private property in Grayton Beach until my parents and others along there got a lawyer involved in the county and rescinded that, and they moved the sign back to restrict driving on the public portion. So the county itself knows the difference between, the county acknowledged they didn't have the right to allow private driving on public driving on private land. Thank you.
Thank you, sir. Sharon, L-O-G-U-E Higgins, Low Higgins.
Yes.
There, okay.
You want me to spell it?
Yes,
You have
ma'am.
it? Okay, it's Sharon, LOGUE-HIGGINS. Okay? I have 6 pages of notes. There are just so many things in my head, I'll never get it all out. One thing that I noticed, I'd been away, I come back, and I see the notice for this meeting, and it is absolute propaganda. When you say we are going to protect the long-standing customary usage, that's a foregone conclusion in your public notice. I don't know if you realize how telling that is about where your heads are at. The whole history, I've read a lot of books about the Indians, about early Florida, et cetera, and I can appreciate the interest in it, but it is irrelevant. Because if my land is customary usage, then Defuniak Springs, all around the lake, all around Freeport, everything else is customary usage, and I can come in your backyards. I can go on everybody's property all along the Intercoastal. So that's not relevant. What's relevant is when we started deeding it for private property. I asked a question of Mr. Theriak about liability. Someone brought that up again. His response was, oh, well, that only happens if there's extreme. That is so irrelevant, his response to me about whether or not I'm liable if somebody gets hurt on my property. I have written many letters to you after each meeting, and I have detailed the problems. I have never had a response, and none of the things have been changed. Even now, with more personnel out on the beaches, I went out in front of my house and picked up glass beer bottles. Sheriff and code enforcement came by. I showed them. Next day, very same girls came down, and I said, I don't want you on my property if you're going to continue to bring beer out of the, your glass bottles. And they said, and they continued to stand and hold their glass beer bottles for me to watch them drink. 2 days after that, I did not see sheriff and I didn't see code. I don't even know if I can call the sheriff at this point because of the things that are happening. Dogs are running all over on the beach too, and nobody's ever watching. And most of them are not owners. They're at noon during the day. I want to say something if I have time. California, to go on the beaches.
Ma'am, address your comments to me, please.
They may be free. You have to pay for parking. Anyone who goes to the beach in California, I have 3 relatives, 2 brothers of mine and my husband's, and they're on the beaches in there. And you can't go there if you don't pay for parking. I grew up Jersey Shore. I have lots of friends and a sister who own property on the Jersey Shore.
You can finish your statement.
Okay. You have to have season badges for that community. Every year you get them for a certain number. So I don't know what she's talking about free beaches, but I have 30 years of experience with that.
All right, thank you, ma'am. Next, I have Ed. Haven't we already done him? Ed Billard, B-I-L-L-E-A-U-D or R-D? Ah, okay, there you go.
Hi, thank you. Ed B-O, it's spelled B-I-L-L-E-A-U-D.
U-D, okay.
Yeah. And I was born in 1954. Glad to be here. I had some stories that related to customary use, but you've heard enough about that. I thought the historical presentation was excellent. Personally, I don't think there's anything wrong with learning a little bit about history, so I enjoyed it. We've heard about the money issue. Money spent protecting freedom is always well spent, in my opinion. I'm in favor of the customary use. My wife and I have owned a home on Eastern Lake for over 20 years. I've been coming down here since I was a child. Prior to that time, we always were allowed to go to the beach without issue until relatively recently. We're not the ones who are trying to take anything away from someone. It seems that it's the opposite, that our customary rights are trying to be taken away from us. And the reason I think it's important to have this ordinance instituted is because this trend won't stop. If we could all just make nice and get along, that would be the perfect situation, the ideal solution to the problem. But the trend is clear. The ones who feel threatened by the public being on what was previously the public beach, want to continue the trend of blocking us out. So that's why we're fighting against this. Certainly no one should condone or encourage any misbehavior of any kind on the beach. That is a completely separate issue as I see it. That's an issue for our law enforcement professionals. It's not the issue that is being addressed here. It's a legitimate issue, and I totally understand their concerns, the property owners. But that's not reason to block everyone from having use of the beach. Those who misbehave should be reprimanded and controlled for their misbehavior. I was going to give stories, but you had enough of those. I'll just give an analogy. We don't live on the beach. We live a couple blocks away. Personally, I wouldn't want to live on the beach, even if we could afford it, which we can't. It's hard for me to understand why someone would want to live on the beach if they are opposed to traditional beach activities. It would be like buying a home next to a football stadium that had been in your town for generations, and then all of a sudden saying, I don't want to have any football activities next to my home. The beach was there. You decided to live on the beach. The beach activities were extant previous to you buying your home. I don't see how you can then try and change everyone's perception that they can no longer have those traditional activities. Thank you again for your time. I know it's a tough job you guys have. Thank you.
It looks like Kristen. Do I have a Kristen here? Oh, good. All right.
Hi, yes. Kristen Nostrand, Nostrand. I've been a Walton County property owner since 2000, coming to the area since 92. I agree with the assessment of the beach use that the historian shared, but everything that he described, from fishing at the water's edge to passing on oral traditions to bonfires, all can take place below the mean high water line. The use being debated is not beach use in the absolute or access in general, rather what has been customary use on the dry sand above the mean high water line. So I'm here today to request that you discontinue efforts to pursue any customary use approach to securing private beaches in Walton County for public use above the mean high water lines. This is based on the fact that it's an irresponsible use of taxpayer dollars. Not only the taxpayers you're attempting to take the private rights from, but all Walton County residents. It's hard to see how the county could ever afford it, even if it did progress to the point of compensating property owners per the Constitution. Based on all available legal assessment of current Florida and federal laws, this pursuit will become exponentially costly, as you can only achieve it on a parcel-by-parcel basis in the state of Florida, and includes compensating owners for the transfer of private land to public use. The BCC has already spent an incredible amount of time, energy, and taxpayer funding to pursue the same objective via the failed beach nourishment easement process and the vote. It's curious how quickly you turned your attention to customary use after the nourishment easement vote failed by over 95%. And this was despite a very suspect approach that included not only a lot of false motives communicated around homeowner protection versus the reality of attempting to achieve 100% control for the TDC and for beach vendors, but also the vote itself when doing nothing was in fact acting against the proposal. Ned, it really does seem incredibly irresponsible to continue this effort and spend further legal fees against what private property owners have already objected to. Ms. Commander, you commented in a previous meeting that private property owners need to remember that God has had a hand in their situation, no different than his having had a hand in all of the commissioners up there having the right to your own private property, as well as the responsibility in your current roles to do right by all your constituents, including those who are very devout and who have worked very hard and made financial sacrifices to own private property as a constitutional right. It's clear, based on all the comments here today, that almost every private property owner is more than happy to share to the mean high water line. It's hard to see why anything else needs to change. People keep talking about this issue as it's about access. I don't know who, the gentleman from Eastern Lake, the access hasn't changed in Lakewood or in Eastern Lake, so the access is still available. Thank you.
Ma'am. Bill Hackmeyer.
Hi. I'm Bill Hackmeyer, Vizcaya. Several comments.
Is it Hackmeyer?
Right. Would you start over again, please?
Hackmeyer.
Right. Please give me my 3 minutes.
Certainly. Start him over.
Several comments about some of the people that want something for nothing. First, the surf riders, I invite them to buy their own private property. Number two, the lady that says, she's from Oregon. Oregon, Hawaii, New Jersey are all socialist states. Florida is not a socialist state. And another, first, I want to comment on, first thing, I'm happy that you guys are buying private property. You're spending $7.4 million to buy 200 feet of beachfront property. That is the way, that is the American way. It is to buy private property. It is to pay for it. That said, what you're doing by passing this law is taking private property for public use under the misguided customary use doctrine, which a lot of these properties do not conform to, the customary use doctrine. And I have some other thing to say. I know your high-powered, your high-priced attorney, Feriak, $425 an hour, has been whispering sweet nothings in your ear, saying that you should sue, you should pass this ordinance so that you can take our private property. But I want to ask you something. Don't you think this guy has a conflict of interest? In case some of you are not math wizards, $425 an hour is $3,400 a day. $3,400 a day times 5 days is over $15,000 a week. That's more than most of these people in Walton County make. And yet he is whispering in your ear, telling you should sue us and take our beach so that he can make millions in a lawsuit, because you are going to be sued. And then finally, I used to wonder about the Honorable, the attorney, I've forgotten his name, y'all know him, used to call y'all socialist. I don't wonder about that anymore. Finally, I would hope you would, one thing, I'd hope you'd help beachfront owners instead of fighting us. Your trucks are constantly driving up and down our beach, putting tracks in our beach. You never will throw any people that are rabble-rousers or whatever off of our beach. Your sheriffs won't do it. Y'all have instructed them not to, or the county attorney has. And so I would think you would work with us. We pay a lot of taxes, period.
Thank you,
and I would think you would do something for us instead of fighting us.
Thank you, sir. Gurnell Chandler.
Hi there. My name is Garner, Garner Chandler. When I signed in to speak, I saw I was following Mr. Hackmeyer, and I thought, oh, Lordy, this is going to be fun. Then the shirt, build the wall. I am an anti-wall kind of girl. I believe that the beaches do belong for the public's use. There are private property rights issues. I have no question about that. However, the ancient historical tenet of customary use law and beachfront properties in particular throughout Europe have been that if you own to the mean high water line, it prevents anyone from building a structure in front of yours. It does not mean, in my opinion, I am not an attorney, so please, but it does not mean that no one can actually have access and use of the beautiful beaches that God gave us. We are very, very fortunate in Walton County, and we're a victim of our own success. I think we can all agree with that. These arguments about prohibiting people from using the beaches, from walking in front of their beaches, from setting up towels, fishing. I hear numerous stories of people getting kicked off beaches for very benign activities. We do have activities that need to be further enforced. Clearly, if somebody goes and sets up a wedding in front of, right in front of your house, that's not right unless it's your own wedding. But we need to enforce the ordinances that we have on the books. We need to implement the customary use doctrine so that it is very clear that those of us who are not fortunate enough to be able to own beachfront properties can actually use the beach. Someone mentioned about access has never been denied. Thankfully, we have good beach accesses in Walton County. Not enough, but we still have good ones. But that's like saying, oh good, I'm going to drive 3 hours to the Grand Canyon, I'm going to get out of my car and look at it, and then I got to turn around. That's not what people come to the beach for. They don't drive to go look at it for 5 minutes and leave. They go to the beach to use it, to sit down in the sand, to read a book, to relax, to enjoy what we have. And I strongly encourage you to pass the customary use ordinance. Thank you for your time.
Thank you. Next, I have Kelly Anderson.
Hi, I'm Kelly Anderson, Anderson.
Thank you.
And first, I would like to thank the county commissioners for having this workshop and for taking this issue on, because obviously it's a very polarizing situation, but doing nothing is not an option. What's going on today can't be allowed to continue. Personally, I wanted to say that I've been customarily using these beaches since the early 1990s. I cover about 2.5 miles every day. I pick up trash, I fill in holes, and I plan to continue doing that. It's really, really sad to me that it has come to this, because back in the day, none of this was going on. I don't want to get into a whole finger-pointing situation, but there's bad behavior on the part of the beach goers, and there's bad behavior on the part of the beach owners. And it's got to stop. All of it's got to stop. I hope you do the right thing. I hope that you continue on this path, because like I said, current situation is absolutely not acceptable. Thank you.
Thank you, ma'am. Next, I have, it looks like Mike Studevant. Okay.
That was close enough too. Sturdivant, Sturdivant. I'm also a resident of Walton County. I own a home in Blue Mountain Beach, and again, I just want to thank y'all for taking up this issue, because it's very important to not just me personally, but to the community, to our county. I think it's going to take courage and conviction for y'all to follow through with this, and I understand we have a very vocal minority of folks who are going to be opposing this, and they have money and they have lawyers and they're going to threaten, but it's most important that you keep in mind first your position. You represent the people of Walton County, all the people. And it's important that you keep in mind that even the folks in the north part of the county, they need to go to the beach too, and they need to be able to get to it, and they need to be able to traverse it. So I just hope you keep in mind that as the county seal right behind you says that we should pay attention to our pride, preservation, and conservation, that you really stick to what you know is true about your role in the community. And it's to stick to that, to preserve our county, to preserve our customary use. And I just encourage you to stay with it and do what's right. Thank you.
Thank you. Next, we have Ms. Brenda Reese. Ms. Brenda?
Commissioners, good to see you tonight, and thank you for taking this position. I want to strongly, and it's Reese, R-E-E-S. I want to strongly encourage you to stay the course and pass a customary use ordinance. It's very important. I was born here in 1953. That's one of the earlier dates I've heard here, and my family's been here since the territorial days. I have been following the use of the beach all my life and have seen pictures from not only currently but before my time of people being able to use the entire beach, not just this high water line mark. So I encourage you to stay the course. I remember back in 2001, our state representative from the area, Representative Bev Kilmer, I believe Senator Clary was the state senator at the time. I believe Jeff Miller maybe was still the congressman from more the Pensacola area, and there was a hearing on customary use at that time. And one of the strong points that they brought up was that something that was public in perpetuity. And so I'd like that might be a new term to kind of look at and understand that it was understood and is understood that what was public land is public land in perpetuity, and the customary use of the beaches is different than, say, the long-standing dispute between Florida and Georgia, which started with the Intercartara of 1493 and went up to the United States Act of Congress of 1872 and culminated in the Coffey versus Groover 1888 Act. So there's borderland disputes, and then this this use of the beach is different. And I hope you keep that in mind. And I've watched all these people move in here, and I've always just walked on the beach. I sit in the sand. I used to dig a chair in the sand and sit there, or maybe took a towel, because as kids we had to haul back to the house whatever we took down. And so I've never had an umbrella or a tent or anything. So that's another issue, though. This is about use of the beach, and if I want to walk back 100 yards and throw my throw my line out and then walk back, then that's something that can be done. So thank you very much. And
thank you, Ms. Reese. Appreciate it. That is the last name on my list. Is there anyone else that wants to speak at this time? Mr. Anderson.
Leonard Anderson, Anderson. I moved here permanently in 2003, and I've owned on the beach since 1991. I don't know exactly how to say this, but somehow it has come to pass that people no longer look at what many of us, including myself, fought for in this country. The beaches are just the same, or should be held in the same context, as our national forests and state forests. They should be able to be used by anybody that wants to use them, as long as they do it respectively. And I cannot understand the attitude that somehow I own the beach. I would like to know, for instance, exactly where, and I have a deed that says I am a private beach owner, but I'd like to know where that right in the deed came from, because it certainly didn't come from the state. It certainly didn't come from the federal government. I think it probably came from some realtor or developer. And that, people, is one of the cruxes of the matter with our beach property ownership now. Thank you for your time.
Thank you, Mr. Anderson. Is there anyone else? Yes, sir. If you'd come forward, please.
David Hewins, Hewins, from Freeport. Thank you, Commissioners, for this brief opportunity. Hearing the concerns of both sides is somewhat disturbing, and I'm very disappointed at the charges of socialism from some parties. I'm in favor of public use of the beach, but I think the proper way to view it is as a public utility. In America, we have a successful history of a mixed economy regarding public utilities. The private users respect the boundaries of the public power generation and water plants, and could probably do the same thing very well with the beach if it were viewed that way. Regulation is indeed a problem. Crime is a problem. Any public utility needs to be regulated, and I think we may have to encourage better enforcement of laws in that area, fund more deputies, that kind of thing. But we really do need to preserve the customary use, public access to these beaches. I personally, I'm not an attorney. I think the mean high water mark designation is vague and subject to interpretation, will probably give rise to more litigation. Also, back to the utility idea, I own a house in Freeport, roughly halfway between the beach and where I work. My property rights, even under a warranty deed, are not absolute. The utility companies have an easement to basically trespass if they need to for emergencies or other public reasons. That's just a small illustration of the idea that private rights are important but not absolute. Thank you for your time.
Thank you, sir. Is there anyone else? Yes, sir.
John Boushy, B-O-U-S-H-Y. Good evening, Commissioners. I may stand between you and dinner, so I hope not to stand long. There's, I think, a couple of inconvenient inconsistencies that need to be pointed out. I know in my situation, Lisa and I, my wife, own to the mean high water line, and we were granted that deed that goes all the way back to the U.S. government. So in my situation, which I think is why the judiciary is a perfect place to make these decisions, it's very fact specific. I don't know about anybody else's deed, but I know my deed was ultimately, it comes from the U.S. government. So I think I should probably feel pretty good about that. It seems like, as I've heard the interactions, and unfortunately I haven't been in Florida for the last couple of months, but as I've watched on the BCC channel, which is fantastic, there seems to be some false arguments that are going on. And I think we heard a lot of beachfront owners talk about, we're not trying to restrict the use of the beach, it's about how it's respectfully being used. They're not trying to restrict access. And likewise, we have a situation where there are occurrences going on both by beachfront owners and by beach users that are not being addressed. They're not being appropriately resolved. They're not being enforced, even against the laws that we have in place today or the ordinances that we have. And I think to wrap up, because I see I have a minute left, I think to wrap up, I would ask you what I heard a number of people tonight say. There has to be a solution to this that is more mutual than what the ordinance seems to provide today. When I step back and listen to all of the comments, whether they are from beachfront owners or beach users, I hear a continuing question of, have we done enough to find a solution that really works for the local people who want to access the beach, for our tourists, and for the people who, at least in my situation, I have confidence I do own to the mean high water line, and that confidence comes from the U.S. government and under the state of Florida and its laws. So it just seems to me like there's got to be another way to get at this, but that's why your job is very hard, so thank you.
All right, thank you. Anyone else? All right, so you and then the gentleman in the blue shirt, okay?
Good evening, Commissioners. My name is Julie Hilton, and my family and I have property in Walton County. My parents currently live here. And I
Is that H-I-L-T-O-N?
Yes, ma'am. The gentleman was just asking something about, there was a question about how a property owner thought that they owned to the mean high tide, and I think the discussion from Dr. Miller explained that the state government sold property to these private owners. So I would really implore you to seriously think about when you, as government representatives, are going to take what government has sold without compensating people, there must be a better way. It's just the amazing unfairness for someone to have spent a lot of time and effort coming up with the funds to buy some property here and paying huge amounts of property taxes year after year. We've been here over a couple of decades, had this property. And then all of a sudden, someone just decide by edict that you're going to take it with no compensation. I don't get it. And I do believe that with the influx of lots of people and tourists and so forth, it has created a problem because people have been led to believe that they could just do whatever they wanted on people's private property. And unfortunately, fortunately, I guess I feel fortunate that I live in a country where we have the opportunity to have our rights protected, even though we're not. Individuals have the right to have their rights protected. I would really earnestly encourage you, before you end up in huge numbers of lawsuits and spend all kind of money needlessly on lawsuits, to please ask your counsel to explain how he expects to apply customary use broad across the board without addressing the individual property. It would be nice for all of us to be able to talk about this rather than you just voting on something and we ended up in court for many years. Thank you very much.
Thank you, Mayor.
Good evening, and thank you for your time. My name is Jack Haynes. Last name is spelled Hanes. I am the president of the Homeowners Association at Sanctuary by the Sea Condominiums, which is between Blue Mountain Beach and Grayton Beach. I'm told that Sanctuary by the Sea sits on a piece of land with 650 feet of beachfront deeded to the mean high tide line that we paid $20 million to purchase. If you think that this is not going to be a very expensive battle if we have a $20 million investment in our land, I have 80 owners who will tell you that's not true. And we are just one small piece of beachfront in Walton County. I've heard a lot of people discuss today what they feel is a lack of access to the beach. I know that this is not a Q&A session, but I will leave you with a question. How many miles of public beach already exists in Walton County through public beach accesses, through state parks, etc.? I would strongly encourage you to spend the millions of dollars that you're going to be spending in a legal battle to purchase more private land and make it public. Thank you for your time.
Thank you. Is there anyone else? Yes, sir. You're going to be the tail end of the dog here.
I definitely stand between you and dinner then. My name is Lee Padgett, spelled P-A-D-G-E-T-T. I again want to thank the commission for taking up this. And one thing that hasn't been brought up tonight that I do want to reiterate or at least bring to your attention is my concern as a Walton County citizen and taxpayer is a precedent. That if you will look back at your minutes from your April 12th meeting when you decided to hire Mr. Theriak, several residents then brought up the idea of also studying the customary use along the Choctawhatchee Bay. And there's going to be other areas throughout Walton County that are going to be subject to possibly coming under the same doctrine. That this particular ordinance only pertains to the beach, but there's a lot of other waterways that, and even Dr. Miller alluded to it in his presentation, going back to the Indians, that they migrated and congregated around the water. That's going to include the bay. That's going to be a lot more land that's going to be involved. So it's separate of the property and the beach, that there's also a precedent that could be of concern.
Thank you, sir.
Thank you.
All right, Ms. Bauschy.
Lisa Bauschy, B-O-U-S-H-Y. I just want to quickly ask, I've heard a few of you express the possibility of perhaps some sort of a committee of people who have an interest in resolving this in a peaceable kind of way that is much less expensive and certainly less contentious. I would ask you to reconsider that. If you've put it on the shelf somewhere, maybe take it out and dust it off and see if we can't work out some things with a committee of constructive, passionate citizens, on both sides. And it seems like you've got enough people to choose from that have shown an interest and will be constructive. So it's just a request that I'd like to make. We don't have to resolve everything quickly, even though I realize you're under a tremendous amount of pressure to do just that. But you don't really have to. You can take a step back and look at it in a little more leisurely way and get some input from people that would like to help you and maybe take some of the burden off just the 5 of you. Anyway, thank you.
Thank you, Ms. Bash. Appreciate it. All right, that seems to be the end of the public comment at this time. Mr. Davis, we are going to have a public hearing on Tuesday. Our meeting starts at 9 o'clock, but we have a lot of things on the agenda. Cannot tell you when it, and we will be taking a look at the draft that your office is drafting now.
Well, Mr. Theriac.
Mr. Bash, and I understand it will be available online by noon on Fridays. Is that correct?
I would think so.
Online at our website at noon on Friday. The draft will be there for everyone to see. Okay? Do you have any questions? Seeing none, we are adjourned. Thank you.